Thank you, everybody, for joining us today. My name is Jiyae Hwang, and I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the EB-5 visa and its rules and requirements. So, just a few housekeeping items before we get started. Some of you may know that the firm was founded on an E2 visa several years ago, and our founder, Ian Scott, is actually in the United States on an E2 visa and has been on several different visas, including F1, TN, B visa, H1B. As such, we know what you're going through. Scott Legal is a full service immigration law firm, and we offer immigration services in a number of different areas, including E2, E1, TN, L1, family immigration, national interest waivers, and of course, EB-5 investor green cards, extraordinary ability visas, and more. We will be continuing this webinar series, and we are doing at least 2 webinars a week on different topics related to immigration law. And at the end of this webinar, we'll be sending out several useful tools to all participants. We'll send you a copy of the PowerPoint presentation that we will go through today. We will also send you a link where you can download guides that go through the visa option in more detail. We'll also send you a link that you can follow to sign up for additional webinars that are coming up in the future. And this webinar will also be recorded and will be made available on YouTube. We will also send the link for the YouTube link. So we encourage you to subscribe and hit the notification button to our YouTube channel, as we do regularly upload a variety of immigration law related videos that could be very helpful and informative to you. We will also send you a link that you can follow to schedule a consultation with one of our experienced attorneys should you wish to discuss your case in further detail. So today we're very lucky to have Ian Scott, the founder and managing partner of Scott Legal PC, to present today. He graduated from Harvard Law School and have extensive experience in processing a wide variety of EB-5 petitions. And finally, for any questions, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, let us get started with the webinar.
Great. Thank you very much, GA. It's great to be here today. And the EB-5 green card is a great green card option. We see a lot of people moving from E2s to EB-5s. We see a lot of people on H1Bs moving to EB-5, and also just people who are even outside of the United States and looking for a green card category inside the United States and outside the United States, looking for a green card category and selecting EB-5. Now, before we get into the detailed requirements of EB-5, let me talk a little bit about the different profiles of investors, and in particular, in relation to the 2 different types of EB-5s that are available. So the first that we'll talk about is regional center. And when we think of a regional center, think of a situation where someone in the US, like say a large corporation, so let's say maybe a hotel chain or something like that, wants to raise capital. Let's say they want to raise $100 million or some large amount of money, and they decide to participate in the EB-5 program to assist with raising that money, and they register with the US government. And they say, okay, well, what we're going to do is we're going to register as part of this EB-5 program, and then we're going to get a number of fairly passive investors to invest money, and then we are going to take care of everything else, right? So we're going to meet any of the other, in addition to, of course, building the hotel, we're going to meet the other requirements of the EB-5 program, and in particular, creating the jobs, such that all that the investor has to do is invest the money, right? So that profile of that investor is someone who is looking for a fairly passive form of investment. They really only want the green card because the administrative fees for these programs are usually quite high. Usually they're between $30,000 and $50,000. And the return is quite low. So the return is usually less than 1% interest. Usually it's a fractional percentage, so less than even half of that. And when you look at that over time, the individual really has negative return. When you look at the administrative fee and the actual return that the individual is going to get, the return is actually negative. So their interest really is getting the green card, really focused on not having to do very much. One thing to keep in mind, though, is that the regional center investment is an investment just like any other investment. So if that hotel chain, for example, went bankrupt and they couldn't build the hotel and they'd already taken your money, that would mean that you wouldn't get your money back and you wouldn't get the green card, right? So these programs are not guaranteed. Someone who decides on a regional center may have less to do in the sense that they give their money and wait, but these are investments and they're not guaranteed by the government at all, right? So the risk associated with these it is real, and the individual understands that. That's why we typically say to individuals that they should get or hire an investment advisor if they have any questions about the terms and conditions of the regional center. The other thing with the regional center is that the regional centers have another benefit in that one of the key things associated with the EB-5 program is the creation of jobs. And when someone invests in a regional center, jobs that are indirect, so let's say, for example, that hotel chain, they're going to have what we call direct jobs, so people working at the hotel, cleaning, front desk staff, people that are baggage people, managers, et cetera. So they're going to have direct staff, but then they're also going to have what are called indirect staff. So let's say because the hotel is there, there's a shopping mall down the street or a restaurant down the street. And that restaurant or shopping mall is not owned by the hotel, but the fact that it's there is a function of the hotel actually being there. So what happens is economists get together and or an economist rather, drafts an economist report and says that, okay, well, there's these are the direct jobs, but then looking at the surrounding area, and they're going to have maybe a dry cleaner, a restaurant, a gas station, et cetera. And here are the indirect jobs, and those indirect jobs can be counted towards the job requirement because once we get into the detail, we're going to talk about what the requirements are. But that is the jobs are an important part of EB-5, and those indirect jobs can only be counted when we're looking at the regional center program. The regional center programs, they're really offered in what we're going to call targeted employment areas, and we're going to describe that in a little bit. And the other big thing with regional centers is that regional centers, by their very nature, is that they can support many, many investors, right? And that is in contrast to direct investment, right? So direct investment might be the profile of an investor might be someone who is in the US on an E2, for example, has started their own business. And that person maybe wants to invest the money that's required in their own business. So they do want control. They do want to manage what the return is or manage the risk and do everything themselves, create the jobs and fulfill all of the requirements themselves. As I said before, the direct jobs or sorry, indirect jobs, you can't count those when the project is a direct investment project. And the other big difference between regional centers is direct investment projects you can only have one EB-5 per entity. And that's something new. That's something that was introduced in 2022. Before you could pool investors together and say, okay, well, if you have 10 investors and they each invest the required amount, each of them can get an EB-5 green card as long as there are 10 jobs per investor that are created. But that was changed in 2022. So now for direct investment, there can only be one green card per entity. So that was a big change in 2022. So the profile of this type of person really is they, probably want higher returns. Keep in mind that for both the regional center and the direct investment, you can't guarantee any returns. So the documentation can't say, oh, this person's going to get 2% or 3% or 4% a year. Can't say anything like that. The documentation also cannot say that the money that the person's invested is going to be returned to them. They can't say that at all. So when someone's investing in a regional center, they are relying on the regional center to some extent because the regional center can't have an exit plan that says that in 5 years we will return your money. You can't say that at all because then the money isn't what's called at risk because someone is guaranteeing the return of it. All of these investments, whether they're direct investment or regional center, they are some form of equity. So you can't say I'm going to loan the company X number of dollars and take back some note. It does have to be some type of equity. Unlike E2, it doesn't have any percentage that's required. It can be anything, even a fractional percentage of equity, and it can be any type of equity. So it can be a membership unit, it can be a share, it can be a limited partnership certificate, et cetera. So all of those would be fine in terms of different types of equity. One of the other big differences between the direct investment and the regional center program is the direct investment program is they're both carved out of statute, but the regional center program requires reauthorization every once in a while. I think the next time it comes up for reauthorization is 2027, but the direct investment program doesn't. So even a few years ago, when there was an issue with respect to the reauthorization, it took about a year and a half for that to get resolved. Direct investments were still a viable path in the EB-5 program because that particular program does not have to actually be reauthorized. So those are the different types of programs. They do have, both programs have a lot of fundamental similarities. There are some differences, but they have fundamental similarities in the sense that they both lead to a green card, and they both have the same investment requirements, and they both have the requirement to create jobs. So now let's go to and really and yeah and just to the next few slides are going to go over the key EB-5 requirements, but just at a very high level, we'll kind of break the requirements into two major pieces. The first one being investment, that you're required to invest money, and we're going to talk about the details related to exactly how much that is. And the second one is that you're required to create US jobs. So those are the two big requirements for the EB-5 program. This is a fairly objective program. Some other programs like E2 use words like, significant investment or, marginality for creation of jobs. But EB-5 is very specific. They have very specific dollar values that they are looking at and very specific job creation numbers. And the other thing that we're going to talk about in this presentation are the filing requirements and what exactly is required when you're filing an EB-5 case. So the key requirements, the crux of the EB-5 program, the first one I talked about was investment. So you're required to invest either 800,000 or 1,050,000 in a new commercial enterprise. Now that's a new business in the sense of, a business that was started yesterday. It could be a business that was started after 1990. And the difference between the 800,000 and the 1,050,000 has to do with whether or not the location of the business. So this is critical, especially when you're looking at some businesses where staff work remotely and things like that. But it's where the location of the business is in a targeted employment area. And a targeted employment area is defined as either an area where the unemployment rate is 1.5 times the national average or higher, or a rural area. So that's going to be defined by the local jurisdiction in terms of population of the area and what's considered rural. Now, the target employment area, there were some changes made in 2022 as well. So it's a little bit more difficult to be qualified as a targeted employment area. Perhaps I say it's more difficult, but really, I think that in the past, people were able to take advantage of targeted employment areas because you could link census tracts together. So even the richest areas of Manhattan were considered targeted employment areas because the census tracts ran through Bronx and different places because they were adjacent. So that was all stopped so that it's a little harder to meet the unemployment rate criteria. But certainly not impossible because the majority, if not all, of the regional centers are placed in targeted employment areas because people want to invest the lower amount. So it's only $250,000 difference, but $250,000 is not a small amount of money, so it does make a difference to people. So the money has to be invested. The key thing to keep in mind is the money has to be it has to come from your personal funds. The one thing you should take away from, or one of the things that you should take away from the EB-5 program is that although they're quite specific with respect to numbers like 800,000, 1,050,000, and the job creation numbers, the program is extremely exacting. So even $1 or $2 that is could knock you out of the program and result in a denial. Just to give you an example of possession and control of funds, there used to be situations where this is when the investment amount was 500,000, and parents would have kids that were in the United States going to school. And the parents didn't want to put the $500,000 in the kid's account for obvious reasons, right? The 21 or 22, 21-year-old, and they don't want the money to be in their account even for a minute because it might not last long. So they instead transferred the money directly to the regional center and then give the child a gift letter. And USCIS denied those applications, saying that the money was not in possession and control of the children, and as a result, it didn't qualify. So now, of course, after those denials, and those denials were never challenged. So those were upheld. Now, of course, we are very, very clear when we are telling people how to transfer money that they should make sure that they transfer the money so that the money's in a personal bank account of the person who's investing. And then once it's in their personal bank account, it's transferred to the enterprise and or the regional center. Because even sometimes if someone may own a business, their own business, and they say, well, instead of transferring the money to their personal bank account, they're going to transfer the money from the business to the regional center or the business to a new business that they want to be EB-5 eligible, and that would take them out of the program. So it is a very, very exacting program. The investment doesn't have to be made at once. What has to happen, what we recommend, strongly recommend happening, is that the investment is all made before you apply, but it doesn't have to be all made at once. So we have a case, it was a farm, and again, this is $500,000 at that time, but they had invested $100,000 over probably 10 years. And that, right now that they have their green card. So when they were ready to apply, we had to go back and look at the money that was invested over that period to come up to the required investment amount. But they have their green card. The investment also has to be, as I said, money that you possess and have contributed to the business, but also like it's not retained earnings. So let's say that you have somebody who's on an E2, for example, and they let's say that the first year they made $2 million in net income, and then the money sat in the company, and then the next year they spent that $2 million. That wouldn't qualify. Those expenditures are not investment amounts. In order for those to qualify, the individual would have to pay themselves a salary or a bonus or distribution, pay tax on it, have the money in their personal bank account, and then reinvest it in the business. And that's the way that it could count. That's not the way we'd advise to do it, but that's the way that it could count. We'd actually advise people to just set up a brand new business so that it's cleaner. But it's just to say that retained earnings, the accumulation of retained earnings over time, doesn't count in terms of E2, EB-5 investment. The source of funds analysis for EB-5 is very different from E2. So E2, the source of funds analysis is, it can be extensive, but especially if you're doing a USCIS filing, but generally it's quite light. The EB-5 source of funds analysis is much more like an audit. So just to give one example, if you were doing an EB-5 case and let's say that someone got a line of credit loan from their bank, and it was a line of credit from a house that they owned. So let's say they owned $1 million house that they didn't have a mortgage on, and then they took out a line of credit or a mortgage on the house, and even if the mortgage document said that they could do, or the line of credit document said that they could do whatever they wanted with the money, the issue would still be the government in this case, unlike E2, the government in this case would say, okay, that's nice. Where did you get the money to buy the house? Right. So then you have to go back and look at the source of funds analysis for that too. And the government doesn't care that these things may have been purchased 20 years ago or some time ago. They still want documentation. Sometimes if the transaction occurred a long time ago, we can argue less documentation, but it can never be zero documentation, right? So we might have to provide corroborating documentation. We may not have all the bank statements, for example, but we may have a tax return, or we may have a job employment letter or something like that. So some type of corroborating evidence, because they really don't care. If you don't have the information, they will not grant the benefit. And as I said, that exercise, the source of funds analysis, is extremely specific, exacting, and much more like an audit. I do believe that USCIS, kind of their interpretation of the regulations, I think that they far exceed the plain reading of of what the statute says with respect to this. And we do a lot of EB-5 cases, and we are very good with source of funds, but even sometimes in those cases, we'll get an RFE, a request for evidence, and have to provide more information, even though there may be, what we consider a significant amount of information already provided. So. The next big requirement, so requirement number two for EB-5 is job creation. So job creation, again, just like the investment amount, it's a specific number. It's 10 full-time jobs. And so a few things with the jobs. So one, they are full-time jobs, so not part-time jobs. There's something called shared jobs in the statute, and we never recommend using that. It's not the same as part-time job. So shared job, it has to be defined. There would have to be some type of contract that kind of says this person is sharing the job. We don't recommend it at all. We recommend you hiring 10 full-time people. And the people, they cannot just be any people. They can't just be people with work authorization. They have to be people with that are either U.S. citizens or green card holders. So we do advise, in particular, if you're doing the direct investment EB-5, that you register for E-Verify so that these jobs are checked. We had the case, that same example with the farm that I was talking about when we filed the I-526 petition. We initially did get it was approved, but initially we did get an RFE for it. And it was interesting that one of the big things the RFE focused on, even though I'm not really sure why they did, was the jobs, right? Because this particular company already had a number of jobs, and just to kind of provide evidence to show that, the job requirement, because you don't have to show that the jobs were created until 2 years after the I-526 petition has been approved. So it's many, many years down the road. But we included some information related to the green cards and citizens of some of the employees who were already there. And lo and behold, one of the big things in the RFE had to do with the fact that some of that information was fake, right? So there were information that the employees gave to the employer saying that this is my green card, but it actually wasn't a real green card, right? So now, in this case, we were able to just argue saying, listen, that's nice that this is fake, but we don't even have to create the jobs yet. We'll deal with that when we're filing the I-829. And that was fine. They proved it. But it is something that's the reason we say to people, you really should move to E-Verify, because it's not hard for people to create this documentation. And if you're like we as a firm, as immigration lawyers, we do very strict I-9 compliance. But most of the people who do I-9 compliance are not immigration lawyers, right? So they may accept a copy of something or something like that, or just that, quite frankly, people are very good at making up fake documents, and it's hard for even an expert to realize it. But E-Verify eliminates all of that, because the government is doing the check, and if these people are already on E-Verify, then when you come to the checking that they're green card holders or U.S. citizens, the government's going to be satisfied with that. The other big thing with job creation is that the money that's invested has to be linked to job creation. So let's just go through an example to describe what I mean by that. So let's say that the individual invested in a company that already existed, and let's say the company already had 5 full-time employees that were U.S. citizens, and they invested in the company. Those 5 employees wouldn't count. And the reason is because the money that the person invested had nothing to do with the development of job creation. So you do have to make sure you are looking at when the money was invested and when the jobs were created if you want them to count, right? If you do want them to count. That's the other reason why, when for EB-5, unlike E2, if someone is, let's say someone is purchasing a business. So let's say that there's a restaurant, and the restaurant has 10 employees, and the restaurant's for sale for $1 million. And then the person buying gives the seller $1 million. The seller takes the $1 million and puts it in their personal bank account and gives the shares to the buyer. That transaction does not count for EB. The $1 million doesn't count for EB-5. It could still be an EB-5 transaction where if they invest an additional 800,000 or $1,050,000 into the business, that could count. The 10 jobs aren't going to count as 10 full-time jobs. But the key here is that when you give the money to the seller, that doesn't have anything to do with job creation. There are limited times where there's an exception to this. With law, there's always an exception. It's something if there's what's called a troubled business, but it's again an area that's an exception. But the general rule is that purchasing a business for EB-5 doesn't work when the money goes to the seller. Now, purchasing a business could work if you invest the money and the money doesn't go to the seller, but it goes into the business, right? And then the plan is for the money that was put into the business to be used for job creation. Then that's no problem. And even if you're getting shares for that, that's no problem, because then you're saying that the employees that are there already, they're not going to count, but you are going to be able to use that money to invest going forward, and that's going to be job creation. So that could be a viable EB-5 case, but it does become a very complicated area. And again, it's something that's different from E2 because if someone was moving from E2 to EB-5 and their E2 qualifications had to do with them purchasing a business, then we would have to back out the amount that they actually paid for the purchase of the business if that amount went to the actual seller. So. We talked about documenting the positions, the full-time positions of the qualified workers. So now, what do we file? So the EB-5 filings, there are a number of forms and petitions, and they they take a long time to get adjudicated. But there's the first one is an I-526 or I-526E, depending on whether you're regional center or direct investment. So this is the one that shows that you have invested the 800,000 or 1,050,000 or and that you're going to be able to create the jobs. So you haven't created the jobs yet, but if it was a direct investment, you'd show a business plan. If it was a regional center, they would have a lot of other documents that show how they're going to create the jobs over time. Because you don't have to have any jobs created when you file the petition. In fact, for years after filing the petition, you don't have to have any jobs created. So then we have the next petition. So if you're in the United States, you can file, and the category is current, and we're going to talk about that in a bit. If the category is current, you can file an I-485 concurrently. This was an amazing change in 2022 because before 2022, you had to wait till the I-526 had been approved before you could file the I-485. Now you can file concurrently as long as the category is current. And this is fantastic because the I-526 can take 4 to 5 years to be approved. So if you can file the I-485, you're allowed work authorization, travel authorization, and most categories are current. In fact, if it's a regional center or if it's a category that is in a TEA, all of them are current for every country. And then if you're outside of the United States, then you would do consular processing, but the consular processing is always going to be done after the I-526 approval. So then once you've had the green card for 2 years, once you've been issued the green card, then 2 years after having the green card, you have to file an I-829 petition. And the I-829 petition is proving that you've actually created the US jobs. And that one is something that, again, takes a while to be approved. But during that time, you get all of the green card benefits because you do get to keep the green card status until that petition has been adjudicated. And the program, so I keep on, or I've said many times that there were changes made to the program in 2022. The investment amount changed. The bigger change was the lower amount. It used to be 500,000, went up to 800,000. The higher amount just went up 50,000 because that was $1 million before. The program, I said that the regional center program had to be reauthorized periodically. The next time it has to be reauthorized will be 2027. But one good thing in the new law is that anything that's filed before September 30th, 2026 will actually be adjudicated because last time when there was an issue with the reauthorization, USCIS just said, we're not adjudicating anything. So for a year and a half, the program was just stagnant, whereas this gives the security that they will continue to adjudicate. I mentioned already that the TEA rules changed where the government eliminated some of the loopholes with respect to that. And the big change as well in 2022 is they had these carve-outs to make certain categories current, and they're still current to this day and maybe will be for a bit. I'm not really sure. The Visa Bulletin's a hard one to judge. But in essence, it's saying that these areas, rural areas, high employment areas. So high unemployment just means areas where the unemployment rate is 1.5 times the national average, or the project is an infrastructure project. These carve-outs are for that, and what it's done in essence is that since 2022, regardless of where the person's born. The people who filed before 2022, if they were born in India and China, for example, still have long delays, but these carve-outs where people filed, and keep in mind that all of the regional center programs are programs that fall into one of these carve-outs. Because they always want to get the B800,000. So that means that someone that was applying from India or China would have a current case, so that they would actually be able to file and get the benefit if they were in the United States, which is a significant benefit. So So the other big change with the act was I mentioned already that the I-485 can be filed concurrently with the I-526, and that allows you to apply for work and travel authorization. There were some other changes like administrative fees. You can't include them, so you can't spend the money because, like I said, they're quite exacting. So if your investment's 800,000, you can't use any of that money on administrative fees, like to pay the lawyer or accounting fees or things like that. So you have to usually we encourage people to invest a little bit more so that you do have a little bit of buffer. Um, but you do have to provide source of funds for that information anyway. So that was a change. That was a change. And then there were other changes that give some remedy if something happens to the regional center through no fault of the applicant. So a few other things to consider with EB-5. The money that you invest has to be at risk. So one of the famous EB-5 cases, it's called Matter of Ho, and that was a case where it was a direct investment where they just invested 500,000, put the $500,000 in a business bank account, made a 3-page business plan, and then applied for EB-5. And it was denied. And the case deals with a lot of things. We cite it often for business plans, making a credible business plan. But it deals with a lot of other things. It deals with the fact that you can't just put money in a bank account and apply for EB-5. You have to spend some money and or committed some of that money. So it could be lease, it could be employee commitments, whatever type of commitment. But that's something to keep in mind. Loans and gifts are fine for EB-5. You just have to keep in mind that the source of funds for those has to be documented. And the gifts, because of the timing of when the petitions will or can be approved 4 or 5 years down the road, you have to make sure if it's a loan that they're making the loan payments, or if it's a gift that you paid the gift tax, because many countries have the gift tax. Because 4 or 5 years when they come to adjudicate the petition, and they're going to ask if this was a loan, if this was a gift, did you pay the gift tax? So yeah, we talked about the considerations for purchasing a business. There's no amount that you have to own. It can be a fractional percentage, but unlike E2. And we talked as well about you can't guarantee return on the investment or the return of the money invested itself. But I think we already talked about a lot of the differences between E2 and EB-5. So. Okay, so let's take a look at a short case study that deals with EB-5. And in this case, we have someone who applied for an E2 in 2015, and they purchased a business for 300,000. The business had 5 employees, and they paid lawyers 40 grand in legal fees. And then a few years passed, and she invested another 500,000, and then she got that money from a gift, and it's through some type of inheritance. And the person who passed away they had sold property or something like that, and they deposited the money. The money went directly into Helen's business bank account rather than going to Helen's personal account first. By the time that additional 500,000 was invested, there were 10 employees, so she'd hired 5 more during that time. And then in 2019, she paid herself the same year that the additional 500,000 was invested, paid herself $100,000 because the company made $1 million. And in 2020, she said, "Okay, I'm going to apply for a green card, and I've invested 1.8 million. The 300,000 I initially paid for the company, the 500,000 that I got as a gift, and then the 1 million in retained earnings that the company made." And she also said, "I've already created the 10 full-time jobs, so I'm good to go," right? And she can hire more people, but she doesn't really want to, and she's in an area where the unemployment rate is 7%. So let's look at a few things. So unemployment rate 7%. So this particular project qualifies as a TEA. And now keep in mind that you do have to pay attention to where the business is located. And then that's also going to, you're always going to have to keep in mind, especially for direct investment, where the people are working, because that's the key. The reason they're giving you the lower investment amount is because they want to stimulate the economy in targeted employment areas. So that's why the location of the business is going to be important, not necessarily where the person lives, but the location of the business, because they're saying the person is coming to the business every day. So now let's look at the, a few things with this to illustrate a few points of things we've talked about. So one is the $300,000 that she spent to buy the business. That was money that went to the seller, so that doesn't count as EB-5 investment. So that's useless in terms of coming up to the 800,000 that is required in this investment. The 500,000 that was invested that she received as a gift, that is likely not going to count either because the money went directly into the business bank account rather than going to Helen first in her personal account. And then the other thing with this is that if the money came from the sale of property from, inheritance from 15 years ago, keep in mind that you still have to show where that money came from. It doesn't matter that it was 15 years ago, 20 years ago, or 30 years ago. They're going to want detail, or that the person has passed away. They're going to want details with respect to that. The other thing to keep in mind with this case study is that the 5 full-time employees that were there initially don't count as for EB-5 at all. So that's another thing to keep in mind. Now, another thing with this case study, the thing to point out is that the bonus that she paid to herself of $100,000, you do have to, especially, I mean, so far none of this money counts anyway, but let's say some of the money did actually count. You do have to be really careful about paying yourself bonuses. Not that you can't do it, but the company would have had to have made money. It did in this case, so maybe it's okay, but you can't take money out of the investment and pay yourself. Right. But it's also just good to know that the money that you invested, you have to be very, very exacting with respect to exactly what you're spending it on to make sure that you're spending it on qualifying things. So we've said already the 300,000 doesn't count, the 500,000 likely doesn't count, and the $1 million in retained earnings doesn't count. So for the purposes of this example, she really has not invested anything for EB-5. Anything for EB-5 maybe we could make an argument for the 500,000 if it was invested put into her personal account and she could prove the source of funds, and then she'd only have to invest another 300,000 because this is a TEA, but she does have to still come up with hiring at least another 5 people if we can count the 500,000, because if we can count the 500,000 and she's hired 5 people after that was made, then we could count the 5 people. But let's say she didn't hire, let's say we can't count the 500,000, then none of the people can be counted because if she now invested $800,000, that was after those 5 people had been hired. So though none of them can count towards the full-time job. So it does get very complicated and tricky as you go through, as this case study, I think, illustrates. Perfect. So a few things, timing. So EB-5s, they're not for people the impatient person, because they do take a long time to be adjudicated. The I-526 takes 4 or 5 years to be adjudicated. The I-829 could take the same amount of time. But again, you can file the I-485 and still be subject to available to have a lot of the benefits of the green card. And you have to kind of look at your current visa and make sure that you are, make sure that you have underlying status and you're looking at whether you're able to travel and things like that. That's in particular if you have a visa that's not a dual intent visa, like a TN visa, E2 visa, et cetera, then you do have to make sure that you're not kind of coming up with having to renew those visas as you're going through the process, or planning that very carefully. And often we have people who go through parallel green card strategies. We have sometimes EB-5s, someone will be on an EB-5 and then they'll marry a U.S. citizen, and then we do the green card for them. We had one client we were doing EB-5 for and NIW, and the NIW was the much trickier case, but it ended up that it was just approved. And so now they don't need the EB-5 anymore. Yeah, and I think planning is really key for this.
Okay.
Perfect. And those are all my results. Marks, yeah.
Yeah, thank you so much, Ian, for sharing your expertise. I don't think there were any questions that came in, maybe give another 30 seconds to see if any last minute questions are around, but yeah, well, I don't think there are any more
No.
questions. You've definitely covered a lot of information, so I'm sure this was helpful for everyone who attended. So yeah, then we'll close here. Thank you, Ian, for your
Great.
time.
Thank
Thanks
you.
everyone to participating today. And yeah, if you have any questions, reach out to us anytime. Thank you.
Perfect. Thank you very much, Jay. Thanks, everyone.